Hi, everybody. Good afternoon. It's so nice to join you to talk about trademarks. My name is Esther Barron, and I am a professor at Northwestern Pritzker School of Law and part of the Donald Pritzker Entrepreneurship Law Center. We'll share a little bit more about what we do at the end of the presentation. We have a few students in the audience as well. And before we get started, I want to turn it over to my colleague Darren Green to introduce himself as well.
Hello, everyone. I'm basically the same as Esther. I'm faculty in the Donald Pritzker Entrepreneurship Law Center at Northwestern. Thrilled to be here today, and I'm going to turn it back over to Esther to kick things off.
So like I mentioned, and like everyone knows, we are here to talk about trademark law. It is actually one of my favorite areas of the law to talk about, especially with entrepreneurs and business owners, because it's so important. And it's one of those things that it's easy to do right initially and really can be very hard, very, very hard to fix later. So I am thrilled that we have this opportunity to have this conversation with you about trademark law. And we would, of course, be happy to answer questions as we go along. This is going to be a very kind of basic conversation or workshop on trademark law. I want to start with something really basic, which is just what is a trademark? All companies have trademarks. Big companies, small companies, startups, everybody, not-for-profits. And it's really any word, name, symbol used by a company or any person to identify their goods or services and also distinguish them from others, from other companies' goods and services. Trademarks can be slogans, they can be shapes, they can be colors, they can even be fragrances. And why are they so valuable? If you think about like Nike, how valuable is that swoosh? It's pretty valuable. How valuable is the brand Nike? Again, very valuable. If you could just sell sneakers, but you had to call them something else, couldn't call them Nike, you'd have to sell them for a lot less. If you think about your own purchasing behavior, I bet you have brands that you're loyal to. I'm just looking around my kitchen. I like Skinny popcorn. I like Dunkin' Donuts coffee. My dog likes Milk-Bone dog treats. These are brands. I like Starbucks coffee in the morning. These are brands, and those brands are protected through trademark law. And you can just imagine how valuable that is to companies, for big companies and for startups. So I want to talk a little bit about how we think about trademark law. We think about it both from an offensive and a defensive perspective. From an offensive perspective, you want to have a brand name that you can protect. You want to be able to stop other people from using a brand that's so similar to your brand that it would confuse consumers into choosing a different company's product or service when they meant to choose yours just because the brands are so similar. And from a defensive perspective, you want to make sure you're not infringing on someone else's trademark because you don't want to get sued. You don't want to get what we call a cease and desist letter. I just got one recently for a client. They're not fun. And it's basically from another company saying, just like it sounds, cease and desist. Stop using that mark because it's infringing on my rights. Darren, in a few minutes, is going to talk about how you figure out if someone else might be out there who could sue you for trademark infringement or send you a cease and desist letter. That's the doing searches and seeing who else might have rights and marks that are similar to your mark. I'm going to talk about how you pick a mark that's entitled to strong trademark protection, because you might be thinking, is my mark, can I get trademark rights? I have a brand. We all have, every company has a brand. How do you get trademark rights? And just by using the mark in commerce, just by simply putting the mark on your product or your label or your website, you get common law trademark rights. So that's super easy. but they're not that great because they only protect your mark in the limited geographic area that you're using the mark. So like maybe the Chicagoland area, if we're all here. Um, the better rights are when you register the mark, federally register with the United States Patent and Trademark Office. We're going to talk more about how you do that. But there's sort of two ingredients. One, the mark has to be strong enough. And two, there can't be any conflicts. So I'm going to focus on how do you know if your mark's strong enough to get trademark protection. And just as a little aside, you may sometimes see the little TM or the little R. The little TM is a company claiming that they have common law trademark rights. The little R is that they've gone to the trouble and expense, although it's not that expensive, to register the mark with the United States Patent and Trademark Office. So then you get to put the little R, which is much better. Okay, so how do you know if your mark is entitled to trademark protection? Is it strong enough? And I'm going to go through a continuum of strength. I'm going to start with the type of marks that aren't entitled to any trademark protection, which are what we call generic marks. Can't ever get trademark protection on something that's generic. And a real easy example is like water. If you're selling bottled water and you call it water or H2O or agua or anything that means water, it's generic and you can't get trademark rights. The weakest type of marks that are eventually entitled to trademark protection or can be entitled to trademark protection are what we call descriptive marks. Descriptive marks are not entitled to trademark protection initially. So you have to acquire what we call secondary meaning in the market. And descriptive marks are marks that just merely describe the product or service. An easy example is like vitamin water. It's just water with vitamins. When they initially tried to get trademark protection, it would be considered descriptive, and they couldn't move from the supplemental registry to the principal registry, marks that are descriptive, until they acquire what I referred to before as secondary meaning in the market. And all that means is, people see the brand and they connect it to the product or service. A lot of business people, you can check yourself if this is true for you, love descriptive marks because without spending any money on advertising or marketing, everybody knows what your product or service does. You've said it in the name. So if I had a shampoo and I could call it like great for curly hair, great for curls, and it was on the shelf at Walmart, it doesn't matter if someone had ever seen an advertisement, they would know right away what my shampoo does. From a legal perspective, we don't love descriptive marks. They can be okay after time and money getting your customers to recognize your mark, but they're the weakest of marks that can be protectable. Suggestive marks are where a lot of times business owners and lawyers sort of meet in the middle. It doesn't merely describe the mark, but it suggests something or hints at the nature or quality of the product without just merely describing it. And so I'm going to stick with water. If you think of Ice Mountain, that is not descriptive because it's not ice that someone chipped away from a mountain. That would be kind of gross, but it does suggest a cool, refreshing drink. If you were hot and thirsty and you saw a water and it was called Ice Mountain, that would suggest a quality about the water that might be appealing. And so suggestive marks are immediately protectable. And so suggestive marks can often strike a good balance between being able to communicate something to your customer, but also having immediate strong trademark protection. The strongest marks are what we call arbitrary and fanciful. So arbitrary marks are regular words with an ordinary dictionary definition, but the dictionary meaning is unrelated to the product or to the service. So I bet everyone can think of a pretty obvious example, which is apple. Apple, if I were selling fruit, especially if I were selling apples, would be generic. I couldn't get any trademark protection. But when I put it on a computer or a telephone or any kind of tech device like an iPad or AirPods, whatever they're called, they become arbitrary, right? It has nothing to do with the tech product. And so arbitrary marks are very strong. And the strongest are fanciful marks. And that's just a totally made up word. It has no meaning, no specific meaning before you create the meaning with your product. So many years ago, I had a handbag company called Elazar, Elezar. Totally made up word. It was a combination of my first name and my business partner's last name, totally made up. If we want to stick with the water example, Dasani, I think Coke owns Dasani, but a totally made up word. And you can see what a good job they've done because we've all heard of Dasani, or most of us have heard of Dasani water. So they've created a meaning, but it's a made up word, so it's fanciful and has very strong trademark protection. So I mentioned at the beginning of this, there's this continuum of strength. So you can think about your own product or service and the brand that you're using, and think about where on that continuum it falls. The stronger the mark, really, the better from a legal perspective. But you do look at your mark compared to your actual product or service. You don't do it in a vacuum because, again, if my mark was banana and I was selling bananas, it's generic. But if my mark's banana and I'm selling meters, I'm just looking at things on my kitchen island. It's totally arbitrary and would be a strong mark. So that is a little bit on how you think about sort of the first test of whether you can register a trademark, which is, have you picked a mark that is strong enough without looking at what anybody else might have? Is it strong enough to get trademark protection and meet that first hurdle that the USPTO examiner will look at when they're evaluating whether or not you can register your mark with the USPTO. The second thing they're going to look at is whether there are any conflicts. And for conflicts, we start thinking about trademark searches. And with that, I'm going to turn it over to Darren to talk about trademark searches. We are going to save time for questions at the end. So please, if you have questions, throw them in the chat and we will be sure to answer your questions.
All right. I always get the conflict part somehow. Thank you, Esther. So as Esther talked about, when you're thinking about your brands, maybe companies that you've started, let's say you've gone through that evaluation that Esther just talked about, and you've determined that your mark is strong enough. It's not generic, it's not descriptive. You're in one of those good 3 categories. So you can check off that first box. Second part of the inquiry, as Esther mentioned, is to determine whether or not there's anybody else out there that's using a similar trademark in a way that would prevent you from getting trademark rights in your brand. So how do we do this? Well, we can run what we call trademark searches. We're sort of searching for anything similar. It doesn't have to be an exact match to what you're doing, but we're searching for, someone else who's out there using a brand which is similar to yours, which might present issues for you. So what does it mean to be infringing on another party's trademark? The test is actually very simple to say. It's creating a likelihood of confusion, right? It's a few words. It's easy to say, but it's not so easy to figure out what it means, right? What does it mean to be confusing? What could be confusing to one person might not seem confusing to another person. So there's a number of tests which those that are in this space, trademarks, will look at to try to figure out whether one trademark would create a likelihood of confusion in the mind of the consumer between your mark and another mark. It's important to remember that there's any number of different tests that you can use to figure out whether there's a likelihood of confusion. No one of them by itself carries the day. Trademark practitioners look at all of them, sort of throw them all into the bucket and then figure out where you come out. The first thing you look at, and this may seem sort of obvious, is how similar are the trademarks themselves. We will have clients all the time that will tell us after we run trademark searches and we find something which is confusing, they'll say, well, I'm going to add an S to my name, or I'll put a the in front of it. And by doing that, I'm no longer identical to this other trademark which existed before my trademark. So you can do that, but unfortunately that doesn't solve the problem. It's sort of sight and sound. So even if yours is plural and theirs is singular, you get rid of a vowel out of your name, like that new age text spelling, and they have the vowel in their name. That doesn't necessarily turn something that was otherwise confusing into not confusing. If somebody would look at the two trademarks and still feel like, yeah, this seems like it might be the same company, it's still confusing, even if there's a little bit difference in the trademarks themselves. But that's certainly the first thing we're going to look at is how similar are the trademarks. If they're exact matches, that's not great. If they're not exact, but they're similar, we have to sort of look at other factors. And if they're different enough, the trademark itself, then we probably don't have to worry. There's probably not going to be a likelihood of confusion. The next thing we'd look at is how similar are the goods and services associated with our trademark. When you establish trademark rights in your brand, you don't sort of own that word or those words. What you have is protection over use of that brand in your little sort of corner of the world. When you get trademark protection, you get it over certain specified goods and services. For example, if I start a tire repair shop, and I call it, Darren Green's Tire Repair Shop. It's not a very creative name, but I'm not very creative. And then there's a Darren Green hamburger restaurant. Maybe not so confusing. Green's Tire Repair, Green's Hamburger Restaurant. Even though the names are similar, the goods and services are vastly different. Nobody's going to go to a tire repair shop and expect a good hamburger. Or at least they shouldn't. So that's kind of the second part of the inquiry, is how similar are the goods and services. Then we get into sort of more kind of nuanced, kind of confusing parts of the test. What they call channels of trade. What channel of trade am I in versus somebody else? But the main parts of the test are how similar are the trademarks and how similar are the goods and services. If they're both very similar, we probably have a likelihood of confusion. If they're both very different, we probably don't. Unfortunately, the world is not that simple. Often we're kind of in the middle where one of them's kind of similar, but the goods and services not so much, where we're sort of trying to figure it out, right? Which is sort of the best we can do. All right, so now we know what the test is, likelihood of confusion. We know some of the things we would evaluate to figure out if there's a likelihood of confusion. But how do we search? How do we find these other mysterious trademarks out there that might be confusing with ours? One thing we can do is something that you probably do almost every day, which is to run a simple search, like on Google, right? So you could go in and type your brand into Google and just see what comes up. Esther mentioned common law trademark rights, right? So anyone who's using a trademark in commerce, as they say, gets some level of trademark protection. Not the strongest, but some level of protection. Those are the kind of trademarks we might find in a Google search. Just to see, are there other, my green tire repair shop example. Well, if I search green tire repair shop and I find a bunch of them already in Google, well, that's kind of a problem, right? There's a lot of other companies using this name in a similar way. So that's one way to run searches. Before we talk about the other way, I want to talk about some searches that founders often think are trademark searches, but are not. They're important, but for different reasons. Number one, let's say you form an entity for your business, and those of you that have businesses have probably formed entities. You have to search the Secretary of State to make sure that the name of your entity is available in the state where you're forming your entity. While that might tell you that you can name your entity something, it doesn't mean you can get trademark rights. They're in two entirely different areas of the law. Getting an entity name only tells you that you can have an entity in the state of Illinois, for example, under that name. So while you do need to get a good name for your entity, that doesn't establish rights in your brand, certainly not nationally across the country. We'll have clients or founders come to us with frequency and say, well, I've got the domain name. I searched all the domain names. There were no other confusing names. And because of that, I must have trademark rights. Unfortunately, that's not the case. having a domain name is important for your business from a business perspective, so you can sort of reach your customers. It doesn't do much for you in the trademark sphere. Somebody else, you can own a domain name for one business, somebody else can own a similar domain for another business. They may not be related. So getting the domain, great for your business, not necessarily so helpful for establishing trademark rights, as Esther was discussing. Yet one more type of search which doesn't do the trick, social media handles, right? So you might say, well, I got it on Facebook and I've got it on Twitter, or X, I guess as it's now called. I've got it on a Snapchat and all the other ones. I'm not so big on social media. Again, great for your business to have all the good social media. Doesn't do much in the world of trademarks. Just because you didn't find another Facebook social media handle which is similar to yours, doesn't mean that there aren't other users of a brand which might be confusing with yours. So those are all important things to do when you're establishing a business for business reasons, but they don't take care of the trademark question. What you do want to do to see who else is out there is run a search with the United States Patent and Trademark Office, USPTO for short. You'll often hear it called USPTO. They make their database of federally registered trademarks available online. You don't have to register. You can go right to uspto.gov. That's their website. And you click on the little trademark box and you go and you'll eventually get to a search box that looks sort of like a Google search box. When you're searching at the USPTO, what you're searching for are federally registered trademarks. Esther mentioned there's two ways to establish trademark rights. One, you just start using your mark, your brand, and you get kind of weak protection, what they call common law regional protection. Or you can file with the USPTO for federal trademark protection. Once you do that, you go into the USPTO database. Anybody at any time, without paying any fee, can go to the USPTO and search the name of their brand. What comes up when you run those searches are federally registered trademarks, the ones that you would worry about the most if something were to come up. You got to be creative when you search. So the first thing you can search is like your exact name of your brand. You might not get any search results. So maybe nothing comes back that's exactly the same as yours. But as we talked about, the brands don't have to be identical for there to be a likelihood of confusion. So you want to be creative. Misspell your name. Get rid of some of the words in your brand. Reverse the words. Think of words that sound similar to the words in the name of your brand and search those words. You might have to run 20, 30, 40 trademark searches to really broadly cover all of the different types of names that might be out there, which could be confusing with yours. And I see Esther put the uspto.gov trademark search in the chat for those of you that are curious. So you want to run these broad searches to see if there's anything that might be confusingly similar to your brand name. So let's say you run those searches. Again, you misspell, you get rid of vowels, you use alternative words, everything to try to blanket the search queries to make sure you get a good, fulsome set of search results. The next question is, what do you do with these search results? Like, let's say you get lots and lots of potentially relevant search results, meaning some names that are similar, some names that might be like exactly the same. What does that mean? Well, one thing it means is if you were to file for federal trademark protection to get the strongest protection over your brand, there's a good chance you wouldn't get it. Because when you file, the USPTO examiner assigned to review your trademark application would find the very same federally registered trademarks that you found in your searches. And if they think there's a likelihood of confusion, they would issue what they call confusingly a Section 2D refusal. All that means is they found a conflict. They will not allow you to register if they find a conflict with another mark. So one thing lots of potentially relevant search results can mean is you can't get federal protection. Even if you didn't find an exact match and you found that like the ones that you did find had different goods and services descriptions, if there's a large number of hits in your search, even if you can navigate through all of that and try to find a way to get federal protection, your mark might not be all that strong. Esther talked about offensive and defensive ways to sort of think about trademarks. The offensive way, let's say you did get a mark, but there were lots of other trademarks that were similar to your mark, even if you were able to get a federal mark. Well, let's say a new company launched and they were using a name which was similar to yours, and you want to send a cease and desist letter to make them stop, the type of letter that Esther talked about. If your mark is weak, there's lots of other uses of your mark. The company you're sending the cease and desist letter to might show it to their lawyer and send you a response saying, I don't think your mark's very strong. I don't think you have the right to make me stop using it. You don't have strong trademark rights over your brand. So while you might get a federal registration, if there's lots of other hits, you might not have strong protection, meaning you can't go on the offensive to make others stop when you see somebody using a mark in a confusingly similar way to how you're using your trademark. So the search results can show you, A, can you get a federal registration? And B, how strong will your mark be? We'll often have clients ask us after we run searches for them, trademark searches. They'll sort of say, okay, so we can be 100% certain that we're good, right? Right? You ran searches, didn't seem like anything troublesome came back. So we can 100% get our trademark federally registered and we'll never have a problem with our brand in the future. Unfortunately, that's not the case. There's no perfect way to run trademark searches. We do the best we can to be creative, as I talked about before, in how we search them, but you might miss something. Everybody misses things at times, or maybe a trademark was cataloged in such a way that it didn't show up in your searches, but it would have shown up with a different search. There's no way to do sort of be kind of 100% sure that you've run a comprehensive search. We do the best we can. Those types of searches that we run ourselves, we sometimes call those knockout searches. Searches that we run on Google and search we run on the USPTO website. There are companies out there that will run what they call sort of commercial search reports for you. They have access to other databases that they subscribe to that maybe you don't have access to. They're really good at running trademark searches at the USPTO. So maybe they would think of a search that maybe you didn't think of when you were running your own searches. You're always free to engage one of these companies. They're just private companies. As you might imagine, if you decide to go that route, you've got to pay them, right? They charge a fee for those services, and it's not always such a small fee. It depends on the type of searches you're asking them to run, but the fee can get, over $1,000 sometimes. Most startup businesses don't have $1,000 to devote to trademark searches with a commercial search company, so they don't use a commercial search company. If you do have such a thing, so that kind of money sitting around, they exist, and now you know about them. You can find one of these companies to run searches for you. So let's say that you go through Esther's analysis and you think you've got an arbitrary mark, so it's a strong mark. And let's say you go through the analysis I just talked about. You run searches on Google and you run searches in the USPTO database, and you don't find anything that you think looks troublesome, or your lawyer, if you're working with legal counsel to do your searches, doesn't find anything that they find troublesome. And you want to establish the strongest rights in your mark. As Esther mentioned at the beginning of our talk, federal registration is the strongest protection you can get in the United States. How do you get federal registration? It's not all that difficult. As intellectual property law goes, like compared to getting a patent, for example, federally registered patents are expensive and complicated and somewhat controversial. Federally registered trademarks are much less money and they take much less time and they're much less controversial. There's an application. You can find that application at that same USPTO.gov website that Esther put in the chat. It's in the trademark section. You can do it yourself if you want to. You don't have to be a lawyer. Now, it may behoove you to have a lawyer because there can be some complications which arise, and having someone who sort of does this work can help, but you don't have to. There's an application that you can file, and you submit it online to the USPTO, where you enter your trademark, you enter the goods and services that are associated with your brand. You tell them whether you're using it already or whether you're going to be using it in the future. There's various pieces of information you provide. If you're using your trademark already, you provide pictures, JPEG pictures, to show them how you're using it. It costs roughly $350. That's what they charge for like a simple sort of basic website or a sort of a basic filing. Certain types of filings cost a little bit more. But it's fairly simple to do, and you file the trademark, and then some number of months goes by, you'll hear from the trademark examiner assigned to your application. And then away you go, and you kind of go back and forth with the trademark examiner. The process can take roughly 1 year. It depends on how busy the USPTO is. There's no set amount of time. But once you file, you've sort of established your place in line. Nobody can jump in front of you at that point. And then once you get the federally registered mark, you can use that little R with the circle that Esther talked about, and you've got national protection. You're in the strongest position to send a cease and desist letter. And that's how you establish sort of federal protection. I see in the chat that some of you couldn't see the link.
I just resent it.
What's
I just resent it to everyone.
Okay, great. Yeah, I think when we post it, might just go to us initially or something. Anyway, so that's searching, that's filing for federal protection. I want to turn it back over to Esther to talk about a few kind of niche areas that can become relevant in the world of trademarks. And as Esther mentioned, we love questions. So feel free to post your questions in the Q&A, in the chat. And as soon as Esther's done with this little piece, we will be happy to answer any questions that you might have.
Thank you, Darren. Sorry, I had to find my unmute button. So I'm going to talk about something sad now, how you lose trademark rights. We spent so much time talking about how you get trademark rights. And I hate to be a downer, but there are ways once you have trademark rights, you can lose them. So federal registration lasts for 10 years. You have to file an affidavit between your 5th and 6th year to show that you're still using the mark. That's for federally registered marks. And if you stop using the mark, you can be deemed to have or presumed to have abandoned the mark. So those are kind of common ways that people lose trademark rights. Kind of a fun way that you can lose trademark rights is if your mark becomes generic. So I talked at the beginning that like generic marks you can't protect, right? Sometimes you could be so good at like marketing and advertising and building your brand that people use your mark in a generic way. It's like so widespread. And examples could be like, you know, I'm going to Uber over to my office. Maybe I mean Lyft, maybe I mean Uber, maybe some ride share. Uber still has their trademark rights, but that's the kind of company that's probably thinking about people using their mark in a way that is maybe making them nervous. It's a wonderful problem to have, right? Like you're so well known. It's like you've done such a great job that you're almost becoming generic. And real world examples are Escalator. Escalator used to be a brand, but everyone just used it for the moving staircase. And now, you know, now you can't have that trademark protection. You can think of lots of examples, probably, you know, Kleenex, still a brand, but people use it pretty generically, right? If you had a box of puffs and I said, could you pass me a tissue, a Kleenex, and you said, I don't have any, I'd be like, really? I see it right there. So really people use Kleenex to sort of describe all facial tissues. Again, they still have the trademark rights, but they're probably a little bit nervous. You can see in advertising, they say Kleenex brand facial tissue, Band-Aids, Velcro. These are all examples of marks that we use just to describe kind of a category. So again, not really relevant, but a fun fact and something that hopefully could be relevant one day as you all build out your businesses, which I'm sure you will. The other thing that I want to talk about is an exception to Darren's rule for trademark infringement. So generally, the rule is the likelihood of confusion, except if it's a famous mark. And if you want to use a mark that's famous, it doesn't matter. Like Darren, I love Darren's example about Green's Hamburgers and Green's Tire Company, Darren Green's Hamburgers and Darren Green's Tire Company. That's not confusing. And no offense, Darren, but that's not a famous mark, so you're fine. But if but if someone, and I think there was a case like someone wanted to have Tiffany's, which is funny because that's Darren's wife, but in this case, that's not who I mean. Tiffany's used tires. That could dilute the brand of the very fancy jewelry store with the little blue box, and that's dilution. So you don't have to be confused. You could just be using the mark in a way that dilutes the brand. So with famous marks, and there's no real test, kind of if you see it, you know it. But think about Nike, Coca-Cola, Starbucks, Tiffany's. These are all marks that are like so well known. They qualify as famous marks, and don't use those marks. Don't, because the test is much harder to pass, and they have a lot of money and will sue you almost for sure. One other example I just want to share is sometimes people will say, well, what if it's my name? Like I could use my name, right? Actually, if it's confusing, someone else is already using your name, you can't. And so, like my name's Esther Barron, but if my name were Esther Fields and I wanted to start a cookie company called Ms. Fields Cookies or E. Fields Cookies, I can't because people would be confused. And you might be thinking, well, that's not really fair. That's someone's name. Yeah, that's your name. Why can't you use it? One thing we didn't mention is that trademark law is really a consumer protection law. Even though the trademarks are so valuable to businesses, we really want to protect our consumers so that when they buy something, they have a reasonable expectation of what they are getting. So it doesn't matter that it's not fair to me if my name were Esther Fields. We want to protect consumers from buying my cookies thinking they were buying Mrs. Fields cookies. And with that, it looks like we have a lot of questions in the chat. So maybe we will start answering some of your excellent questions. And Darren, do you want to take the first one?
Sure. Yeah, I'm seeing a lot of great questions. Keep them coming. We love the questions. I'm going to start with a question. What other things can or should be trademarked other than business name or products? And that's a good question because it can sort of get confusing, the different areas of intellectual property law. Think about Nike. Esther mentioned Nike. So Nike would trademark first its brand, Nike. So the word Nike is one trademark. Nike has the very famous swoosh that we've all seen that Esther mentioned. Well, that's another trademark, right? That swoosh can be trademarked. Nike, I don't know if they still say just do it, or if I'm like 20 years ago, I'm not up on things, but they did at one time have that slogan, just do it. Well, Nike might have trademarked the slogan, just do it. Those are all things associated with their brand. So your name, your logo, taglines, and think of a big company. Think about Microsoft. Well, they might have trademarked Microsoft, but then they've got a bunch of brands, Microsoft Excel, Microsoft, Office. I'll think of all the different Microsoft Word, all these different things that we all use from Microsoft. Each of those sort of softwares that are sitting under the umbrella Microsoft brand can also be trademarked. Big companies can sometimes have hundreds of trademarks because they've got all these different products that they've launched under different names. So those are things that you might think about trademarking. The product itself, like its functionality, all of that, that's a different area of intellectual property law. That's not your brand. That might be a patent or a trade secret or something like that, which is beyond the scope of what we're talking about today. But all of those things I mentioned are all trademarkable and things that if they're valuable to you, if you're sort of building up goodwill behind a logo and you have the budget for it, it's probably worth searching and filing for protection against it. Esther, I'll turn it to you for a question.
I'm going to answer two because one's really short. How much does a search cost? And I think probably the question is how much does a commercial search cost? Darren kind of mentioned this. They can be about $1,000, sometimes a little bit more. I thought the question was how much does the application with the USPTO cost? And that's a few $100s. It's about $300. So a really good value. But then I also see a question about someone who was confused about the statement of use, filing a statement of use. It doesn't explain the statement of use. And so I just wanted to go over that process a bit. So sometimes if you're not using your mark in commerce yet, so when you submit an application, generally you have to attach a specimen. Darren had mentioned that shows how you're using the mark in commerce. If you're not yet using it, but you want to hold on to your name and you have a present intention to use that mark to sell your product or service in the next 6 months, you can do an intent to use application where you don't attach specimens. You can ask for extensions of time for 2.5 years, so you can do it a bunch of times. But if you submit an intent to use application, what you will get if they do the search and they say, okay, this name is strong enough and we don't see any conflicts based on the way you described how you'll be using it, we'll send you something called a notice of allowance, which means you've kind of passed the hurdles. The last thing you'll have to do to get the registration is submit the specimen. And that's what the statement of use is. It's the thing that you submit after you get the notice of allowance saying, okay, I'm glad you didn't find a conflict. I'm glad you think my mark is strong enough. Now it's been 6 months and I'm now using it in commerce. Here's a specimen showing how I'm using it in commerce. And that's what the statement of use is. So hopefully that answers your question and I will pass it back to Darren.
Thank you. I see a question here. It's a good question. They're all good questions. How does the USPTO determine the threshold between descriptive mark and suggestive mark? How can we determine if a mark obtains secondary meaning? If we only had the answer to that question, but we'll do our best. And the reason I say that is there's no right or wrong answer. When we talk about trademark law, one of the frustrating things for founders when they first start to try to protect their brands and their logos and their name and all that stuff is that there are no bright line tests. There's no sort of certainty that, yes, I know my trademark is going to be strong and I know it's going to go through. All we can do is sort of evaluate the mark and then take our best guess at it. The line between descriptive and suggestive, those two categories that Esther talked about, how strong your mark is, that line is one of the most evaluated lines in all of trademark law, because if you're descriptive, as Esther suggested, you can't get immediate registration. You can't get immediate protection for your trademark. Yet if you're suggestive, you can, right? So it's a big deal whether you're descriptive or suggestive. How do you make a determination? Well, the first thing you can do, think about it yourself and maybe talk to some of your advisors, right? The more minds that you can put on this, the more opinions you can get. If everybody is coming back and saying, yeah, that seems like it really describes what you do, well, maybe that's an indicator that you're more likely to be descriptive. Maybe the examiner assigned to your trademark application will feel the same way that your team felt. Not necessarily, but at least it gives you some sort of indicator. The other thing you can do is you can run some searches at the USPTO. Here you're not running searches necessarily to find a conflict or a potential conflict with your mark, with your trademark. Maybe you're looking for other examples to see if other marks with sort of similar type words were able to get through, and that the examiner for those trademark applications did not find them to be descriptive. You would know this because if an examiner finds a trademark application, if they find the trademark to be descriptive, they'll say it. They issue what's called an office action, which is nothing more than a communication from the USPTO to the trademark applicant. And if they think that your application, your mark is descriptive, they'll come back to you and say, you can't have immediate protection because this mark was descriptive. You can, when you file for federal trademark protection, all of the communications, most of the communications back and forth between you and the USPTO are of public record, meaning you can see for other trademark applications, the back and forth between the examiner and that trademark applicant. Maybe in running searches, you can find some similar cases to yours and at least see what the examiners felt in those cases. Examiners are not bound by precedent in the same way that like a judge would be in a court of law. So even if you found some examples, your examiner assigned to your trademark application might feel differently. But again, at least it gives you a sense as to how examiners have dealt with similar questions to what yours is. I know that that's an entirely unsatisfactory answer that I just gave, but it's the best I can do because there is no right or wrong way. There's no one way to figure out where you're going to fall on that continuum. With that, I'll kick it back over to Esther.
Thank you. Thanks for all these questions. They're terrific. What if the trademark existed but then was discontinued? So once a trademark has been abandoned, anybody can use the mark. You don't hold on to rights to a trademark forever. There was actually a company out of Chicago that used to take abandoned brands, trademarks that had been abandoned, and start new products using that brand and try to capitalize on the sort of the goodwill that had been previously built up in those brands. So some of the things that like Darren and I grew up with that are no longer used, but that we remember, he would use those company names. Like I'll give you an example, like Nuprin, I think was one. Nuprin had been abandoned, even though we all knew what Nuprin was. Little Yellow Different, I think, was from a movie. And then you can acquire trademark rights in a mark that someone else has abandoned. And that's actually why it's such a good point. If you were to be like a brand manager at a big company, say Procter and Gamble, my guess is if you stop using a particular slogan or logo or trademark for a period of time, but weren't intentionally trying to abandon it, your general counsel would be calling you and saying, on your next package, I want this slogan. I don't care if it goes with your theme or not, because if we don't use it, we're going to lose it. It is use or lose, unlike patents and some other types of IP. If you abandon trademarks, anyone else can acquire the rights in that mark. So hopefully that answers your question.
All right. So I see a question, sort of a specific one here. Can I sort of get a trademark, the name of a food truck, right? So if your business is a food truck, the answer is possibly. You would go through the analysis that Esther and I talked about. So if you have a food truck named whatever it's called, food truck, that's a brand, right? So you couldn't trademark like the food itself. You couldn't trademark, the product, but that's your brand. So you would first go through Esther's analysis. How strong is my mark? Is it suggestive, arbitrary, or fanciful? Those are the good categories for strength of mark. Then you'd search on Google, search at uspto.gov. If it still looks clear, you're not finding food trucks that have a similar brand or restaurants that maybe have a similar brand to yours, you would then decide whether you wanted to file for trademark protection. And if you did, and you got the mark, you could use the little R with the circle of it right on the side of your food truck, right where you have your name, so people know the brand of your truck. So the answer is absolutely. The food truck, there's no reason that you couldn't go through this analysis and potentially protect your brand, depending on what you find in running through these different analyses that we've talked about. And I will turn it back over to Esther.
Can you trademark your business? Oh, is that the same? I thought I saw, oh, this is the business name on a food truck. I thought someone asked, could you let me just see. Oh, I think we might be, am I missing? I don't see any other questions. Let's see. Thank you.
I've got another one if you want me to hop in on it.
Yeah, hop in.
I'll
Oh,
hop in while you're
yeah.
perusing.
Thank you.
If a trademark is famous in another country but not registered in the US, can I register it? That's a great question. So trademark law is a creature of the countries where you are. So United States has trademark law. The European Union has trademark law. There's different trademark law in Southeast Asia, Mexico, other countries. They all have their own set of trademark laws. What we're talking about here, registering with the United States Patent and Trademark Office, that provides protection in the United States, not in Canada, not in Mexico, not in other countries. You're establishing rights in the United States. Similarly, if a trademark holder has a trademark in Spain, for example, and they're not operating in the United States and they haven't registered their mark in the United States, we can assume that they don't have trademark rights in the United States. I might operate a business in the United States under a similar name to the business they're operating in Spain. And as long as we haven't taken steps to get protection in the other country, that's perfectly fine. There are ways, and it starts to get a little more complicated. There are treaties out there. So let's say I'm launching my brand in the United States, but I know that I'm going to be operating internationally. Well, under these treaties, there are ways that I can file in one central location and maybe get a protection across much of the European Union or certain countries in Southeast Asia. So you can get protection internationally, but you have to sort of do more than you would do if you were getting protection in your country. Most early stage businesses start with the United States because that's where they are. And for many businesses, that's all they ever need. They're not intending to open locations or offer their products in other countries where they would be worried. But it does exist and it's available. Should that be something you need? Again, that's you probably need to work with a trademark expert, a practitioner who's dealt with sort of international protection, because it starts to get a little more expensive and a little more complicated. With that, I will kick it back over to Esther.
And so someone asked if the Northwestern has a clinic that helps small businesses. We do. That's where Darren and I work. It's the Donald Pritzker Entrepreneurship Law Center Clinic. And I put a link to our application in the chat. We generally take new clients at the beginning of each semester. So like end of August, early September, and then again in early January. So we do lots of trademark work. We're actually even in a program with the United States Patent and Trademark Office. So we have designated examiners. We do not charge for we don't have costs. We don't charge we don't have any fees other than costs for the application, or if there are any government or, like sort of third party costs, but we don't charge for our time. So if anyone's interested, a good time to apply would be end of December, maybe even end of November, and put on the application that you went to our workshop. And I will do a substantive question also, which was someone asked about state trademarks, which is an option if you are only going to be running your business in Illinois or in a particular state, and you only need protection within the state. Great. State protection is you can file a trademark application and get a registration with the Illinois Secretary of State. And in fact, if you're only doing business in Illinois, you can't get federal trademark protection. So in order to get federal trademark protection, you have to be offering your goods and services outside of just the particular state that you are in. It has to be interstate. And with that, I will pass it back to Darren.
I see a question here for a clothing line. Would I be trademarking the name of my brand or the logo created for the brand? What if there's multiple designs? And the answer is either of those options might work for you. Let's say that you have a name of your clothing, your clothing line, and that's the name you're sort of holding out to the public. So pick a creative name for a line of clothing. I'm not able to do that. That's probably protection you would want. So one trademark application and set of searches might be against just that name. Let's say you've created a logo, as you suggest in the question. You can trademark the logo. So if you're using that logo, if you're really putting that logo out in the marketplace, and you feel like the general public is getting to know you by seeing that logo, even if they don't see the name of your business, that logo is pointing to you. It's becoming important for you. Then you can actually file a separate trademark application just against the logo. Take Starbucks, for example. We've all seen that logo all over the place. I haven't run a search on it, but I would certainly guess that Starbucks has trademarked that logo many different ways, right? Because it's such a logo associated with their brand. For early stage businesses, it's all a function of budget. So you might say, look, I can't devote $5,000 to filing trademark applications. I need that money to hire people and to market and do all the other things that businesses need to do. So I'm going to start with my core brand, the name of my business. I'll protect that. And if the budget allows for it later, maybe I'll file against my logo. The other thing that we often see, especially in early stage businesses, is that logos often change. So if you have a logo and you're not really set on it, you kind of just picked it and you sort of threw it out there. You're going to see if it really works or not. You could also wait a little bit and see, is this a logo I'm really going to stick with? Because if you file against a logo and then you change the logo, you're not going to get much value from the money you spent on that first trademark application. So we'll see startup companies and founders sometimes like a year or two later, if they've really stuck with their logo, say, now I'm ready to also protect my logo. So you can do it any way you like. It's whatever's important to protecting your brand. And I'm going to turn it back over to Esther.
We're getting close to the end of our time, but we have a couple more questions. Someone asks if there's a list of abandoned names. Unfortunately, no abandoned marks. There's no list anywhere that I know of. Usually when it comes up is when you're searching a mark and you're on the USPTO and you're searching for a mark that you want to use and you find one that's already been registered, and then you're delighted to see that it's actually been abandoned. And so those rights will not create that mark will not create a conflict for you. I think the company that I mentioned earlier where the startup that tried to take over abandoned brands, I think he just like thought of brands that he remembered from, I guess that's where he came up with them. But no, there's no list of that I know of abandoned marks out there.
And I'll take one more. I think as Esther mentioned, I think we're getting near time. I just want to reiterate, we would love to see applications from as many of you as possible. If you've got trademark work for maybe the next semester. So do check out the link Esther sent. We love working with companies that we meet through these presentations, and we'd love to work with some of you as well. So don't be bashful. The question I see, after getting an LLC and buying the name of a website, do I still need a trademark? Good question. Lots of founders stop there, right? They get the name, they form their LLC or their corporation, whatever entity they choose. They get their website. But as noted earlier, you don't have trademark protection at that point. All you have is an entity by that name, and you've got a website under that name. If you want trademark protection, you either have to start operating the business and you get that weaker common law trademark protection, just kind of regional where you are, or you need to file for federal protection, what we've been talking about. If you really want to establish the strongest trademark rights, you'll not only get an LLC, you'll not only get the website in place, but you'll search and then file for federal protection. And that will give you the strongest protection, both to defend your use of the mark and to get others to stop using the mark should you want somebody else to not be confusing with you. And I don't know, do we have time? I think we're kind of at time, unless Esther, do you think we have time for one more or no?
I think we're right at time.
Yeah, I think we are.
Unfortunately. But we are so grateful that you all spent the last hour with us. Thank you so much. And like Darren said, please reach out to us or use the link to apply if you're interested in working with our clinic. But thank you again. This was a lot of fun. And thank you for the awesome questions.
Yeah, thank you, everybody. Great speaking with you, and have good weeks.
Thanks to Darren and Esther for today's presentation. It looks like our attendees got a lot of great information that they can use. I hope everyone signs up for their program over there at Northwestern. If you are a part of the BACP Entrepreneur Certificate Program, your account will automatically be reflected for your attendance today within 24 hours. To learn more about our upcoming programs, please visit chicago.gov/BACP webinars. Thanks again to today's presenters, and everyone have a great evening.